Good afternoon, everyone. Welcome to this webinar on the hot subject of Germany, hosted today by Giant Group in partnership with Osborne Clarke. We've got quite a few people joining the call today, so I'm just going to wait for a few seconds as people come through. If you want to get yourselves familiar with the functionality on the webinar, please dip into the chat function, say hello to everyone, let us know where you're registering from. We know we've got people joining us from across Europe, so it'll be interesting to see where you guys are based. And I'll probably wait another 10 seconds or so and then we'll start. Okay, we've still got people coming in, so I'm just going to wait another 20 seconds or so, and then we'll get going. Okay, it's just starting to slow down now, so I think we'll get started. Good afternoon, everybody. Welcome to this webinar hosted today by Osborne Clarke and Giant Group, and with a particular focus on Germany. I think over the next sort of 45 minutes or so, what we're going to be looking at trying to address is understanding some of the compliance and legal considerations that businesses should be aware of when you're looking at hiring workers that are based in Germany. We're really pleased that we've got a good audience today, a good mixture of both recruitment businesses and end hirers from what I can see from the attendee list. So we'll try and accommodate both those audiences as we go through the session. But I think we all recognise, no matter where you operate, there's absolutely hard talent shortages across the market. Many countries and industry sectors are being impacted by this, and the use of contingent workers is definitely on the increase to try and address the skill shortages. So I think it's more and more the case now, whether you're a recruitment business or an end hirer, that you're looking at tapping into this contingent workforce to address these challenges. But of course, there are a number of considerations to think about when you're engaging with contingent talent, particularly on the legal aspects. So we're hoping to debunk a few of those areas today and explore them and give you guys a little bit more comfort on the risks and how to mitigate them. So specifically, there's a couple of topics that we're looking to address. First of all, I think it's really important that we go through some of the terminology and the language that's used. It's often the case there's differences there between terminology in country, so I think that's important just to set the scene. We'll then move on to the thorny issue of worker classification. I don't think it matters which country you're based in, that's a challenge for everyone. So we'll talk specifically with Thomas about how that's dealt with in Germany. And we'll look at various ways that workers can be engaged by companies, and also the types of providers that you can use to help supply those workers, and what you need to be thinking about from a legal perspective in terms of licensing and payment requirements, and maybe trying to highlight some comparisons to the UK. I hope there's going to be plenty of questions today, so please do send them in via the Q&A function. We'll probably leave about 20 minutes or so at the back end of the session to be able to answer those questions, so please do feel free to punch those in as we go, and then Thomas and I will try and work through those as quickly as we can. So I'm delighted to welcome Thomas today. Thomas Leister is a partner at Osborne Clarke's Germany office. Thomas supports many businesses and foreign companies who are looking at using individuals and to resolve sort of collective labour issues, with a special focus on the development of concepts for companies in recruiting workers, with a particular focus on the recruitment industry. He looks at lots of different workforce solutions, so concepts like PEO, employer of record, agile work, probably throw platforms into the mix there as well, Thomas, as well as engaging independent contractors and working with businesses that support with MSP and RPO contracts. So we're really privileged to have an expert on the call today. I'm Dan Haslam, I'm Group Sales Director for Giant, and I'm going to be the host for today's session. And what I'll try and do to lead the conversation is use a number of set questions that will help us steer us through the topics that we've outlined. as well as trying to highlight some of the practical ways that we can mitigate some of those risks. As I said at the beginning, please do submit your questions as we go through via the chat function, and we'll get through those at the back end of the session. So I think let's begin then by firstly looking at our first topic, which is the terminology used when discussing contingent workforce. There's often variations between countries, and sometimes that can lead to confusion when we're trying to explain scenarios with clients and colleagues. So let's try and demystify some of that today. Thomas, good afternoon.
Good afternoon, Dan, and good afternoon to the audience. Happy to be here and share some insights from the German market. Let's start with the terminology. It's mainly similar to the US and the UK, but there are differences in detail. We have some specific terminology that is not known in the other countries, and we would like to introduce you to that so that you understand what I mean by saying, for example, self-employed means independent contractor, sometimes also used as freelancer, and that's the main differentiation between dependent employees and self-employed persons. Next to that is the sole trader, the freelancer. We call it solo Selbstständiger. That means a solo self-employed person, an individual person who works on his own. Sometimes this person is called Freiberufler in Germany. You might have heard that. Freiberufler is a freelancer, an independent contractor, but it means originally it means a specific type of a freelancer, like lawyers, architects, tax advisors. But in the industry, it's mainly used for all types of freelancers. I do not use the word Freiberufler. I use independent contractor or freelancer. And then we have limited companies, OLCs, own limited companies. In Germany, it's in general the GmbH, so a company with limited liability. Consultancy is also used in Germany. We call it Beratung. It's sometimes also an agency. And then we have a specific type in Germany. They are called Zeitarbeitnehmer, AUG workers, and that's similar to temporary agency workers. So these are employees employed by a recruitment company, and they do not work for the recruitment company, but for their clients. And that's under the AUG, that's the German Employee Leasing Act, and therefore we call them IEG workers.
Cool. I think that definitely makes sense, and I know there's some particular interest in understanding a little bit more of the AUG piece and the sort of restrictions around that. Perhaps we can talk about that a little later on. Interesting that you were saying that there's two flavors of sole trader. Then would it be the case that the Freiberufler reference is more for sort of white collar professional type workers?
Yes.
Okay. I think it's really interesting. I mean, there's definitely some similarities there, Thomas, in terms of the references that you're using and what we would talk about from a UK perspective. I think probably not in terms of the workers that are supplied by recruitment businesses. Then really the definition underneath that is really just how those workers are engaged. So whether or not they're engaged as a permanent, as an employee, or whether or not they're engaged as on a corp-to-corp basis. But there's no real distinction, I don't think, in the market around whether workers are engaged via clients or via agencies. There are a separate set of rules, obviously, that apply to recruitment businesses, but not so much in terms of sort of the way that the workers are engaged. I think this concept of EOR and AOR is something that we should probably talk about and just get everyone clear on. So you'll hear these sort of acronyms referred to as we speak, and simply put, what we're talking about there is employer of record for EOR, and then agent of record tends to be things like you've mentioned there, the corporation payments to a GmbH business, or where you're engaging a company rather than engaging a person, an actual person on an employed basis. So yeah, I think that was really useful in terms of understanding the language that's used. So maybe in the next section, what we'll go on to is the hottest and thorniest topic, which is worker classification. I don't think it matters what country you're sat in, or when you're talking about this matter, it seems it's a challenge for most governments, and it's a challenge for most businesses who want to make sure that they're engaging people compliantly. And so trying to understand whether or not a worker should be engaged as an employee or could be paid as a company is super important. Obviously, we refer to these rules in the UK as IR35, but I'm really fascinated, Thomas, to hear about how you operate those rules in Germany and the sort of processes around the concept of worker classification.
So it's quite similar to the US and the UK. Since we work on global projects, we know how it works in the US, in the UK, and then in Germany and in other countries. The main criteria that we see is, on the one side, monitoring, directing, controlling the person, and then integration into third parties or clients' organization. There are differences in detail. So the main difference in the recruitment industry is it a dependent employee or is it an independent contractor? And the difficulty that we have in Germany is that we have a law. It's stated what is an employee. However, this definition does not really help. So we have a case law for several decades, and this case law was put into this law. So you need to understand what case law decided in the past, and we have a lot of criteria, and at the end, a court will say, we will not have a look at some of the criteria, and there is not one criterion better than the other ones. We will have a look at all the criteria in the individual case, and then we will assess, is it, or determine, is it an independent contractor or a dependent employee. That means we have a quite high legal uncertainty, and that's not good when we talk about the status of a worker. So the main criteria that are used when assessing the status is personal dependence on directives regarding the place of work, the time of work, the specifics, the content of the work that is performed. That's one point. So monitoring, directing, controlling. And the other point is integration into a third party's or the client's organization. Then there are a lot of other criterions, like entrepreneurial behavior in the market. Does the worker has an own office, an own equipment, own company car, own email address, own website, LinkedIn, social media, whatever. Insurances, very nice topic. And then, as I said, the court will have a look at all the criteria and then decide, we think this is an independent contractor or a dependent employee. When thinking about the status, or when thinking about engaging a worker, the first and most important question is, for which services do I need the worker? So you should not ask, oh, I would like to work with an independent contractor, but you should ask, I have this specific task and this needs to be done. how can this be done? And it could be that it can be done by an AEG worker, by an own employee, by an independent contractor. In some cases, it's not possible to use an independent contractor. Yeah? For example, if you would just like to replace a dependent employee who is now on sick leave, parental leave, maternity leave, whatever, then you should not use an independent contractor doing the same work than the employee. That's not good. So that's the first question. Which type of work and which kind of contingent workforce can I use? Then the next step will be the proper contract. That's relatively easy. Yeah, when we know this shall be an independent contractor, we can prepare an independent contractor agreement. Fine. And then the third point, and that's the most crucial one in practice, is this contract executed in practice in the right way? That means lawyers can provide you with any contracts, yeah, the nicest contracts, but are they executed in practice? And if there are deviations between the contract and the practical execution will prevail. It's sometimes difficult for authorities or courts to check this, but they can do this. And therefore, please ask yourself before you spend a lot of money for contracts that you can't use in practice, is this the right contract for the respective task? And then this is the starting point, the task, the services, the contract, and then the practical execution. And that's relevant to avoid worker misclassification.
Yeah, I mean, that's super useful. There's definitely some common themes there, Thomas, and sort of things that we'd see in the UK, you know, supervision, direction and control, part and parcel of the organisation. So that makes sense. And unfortunately, another common theme is that it's completely grey and a little bit opaque. There's no real clear definitions around it, and it's left to interpretation. You're not going to know what the result of a classification case is until the judge has made a decision, which is not really helpful when you're looking at trying to make decisions on engagement at the beginning. In the UK, we've done a little bit of, well, there's some businesses that have tried to do some work around trying to model worker classification, IR35 decision making around like nests of questions. I wonder, is there any similar sort of platforms or questionnaires in Germany, or has anyone tried to achieve that sort of approach?
Yes, there are, and we also prepared questionnaires. We implemented a compliance, an independent contractor compliance navigator to help the market with some relevant questions and comments to get an understanding of how it works in Germany. But at the end, it's quite difficult. There are some that say, if you use our tool, you will get an answer with legal certainty. Yes, that can be the case, but it does not really help you if it's, in most of the cases, oh, this is worker misclassification. Oh, there's a high risk and this is worker misclassification. So that does not really help. And our approach is, yes, it is risky, but you can use it, you can do it, but you should be aware of the specifics of German law, and not only law, because this is very important. When it comes to contingent workforce, you need to understand how the authorities and the courts in Germany act. That's important. I will make a little example. Usually, if you're not happy with the decision, you can go to court. And the court system in Germany is relatively fast. So you will get a decision and also a final decision within a short period of time. When it comes to the status of a worker, it will be relatively fast in front of the authority. That's the German pension fund, the Deutsche Rentenversicherung. they will make a decision relatively fast in most of the cases. Usually they decide that it's a dependent employment relationship. Then you can go to court, and now it starts taking time. One instance in front of the social courts is about 3 to 4 years. And I have an ongoing court proceeding for more than 11 years now. And there's still no final decision. And that means in most of the cases, when we are talking about worker misclassification or the risk of worker misclassification, you can't wait more than 10 years for a final decision. Yeah, when you think about the legal consequences, the back payments, the interests, and then it's maybe not just one independent contractor, it's maybe 5, 10, 20, and that's not possible. And therefore, the authorities know this, and you have to understand this. And also we as lawyers have to know this, because it's not really helpful if we say, oh, the decision of the authority is not okay, but you can go to court and then we will win, or probably win. Yes, but if it takes 8, 10 years, you can't do this. You need to understand how the system works.
Yeah, very stressful. I think so definitely using a tool is not a get out of jail free by any stretch of the imagination. And we've got the same challenges in the UK, with some cases taking, years and years on appeal to go through and classify. So I wonder, moving on, is there any other practical suggestions for the audience in terms of how they can try and mitigate some of these risks around worker classification, Thomas?
Yes. So of course, the easiest approach is thinking about implementing a contingent workforce compliance program, and that can be relatively small. Yeah, you can start with some little steps and then increase it, but you do not need to spend a lot of money for this. So the first thing is you need to have proper contracts. That's really important, because if the contracts are not proper, the practical execution will not be better. Then practical execution needs to be fine. Therefore, you need to know how can I engage independent contractors in a proper way in Germany. Therefore, such checklists or navigators or whatever they are called, they can help to get an understanding what is important. But those criteria they develop, and some of them are still in the market but no longer relevant. Yeah, for example, working for different clients should be a good indication for an independent contractor status. Yes, in most of the cases it's the case, but if you're talking about a solo self-employed worker, an individual person just selling his working time, he's booked on a project for a client for 2 years, and he is a very specialized, highly skilled worker. He just works on this project. Yes, he can be an independent contractor. He does not need to have several clients at the same time. And the court said even employees can have several clients, several employers. You can have a main job and then a mini job, or you can have several part-time jobs. So that's possible. And then the next step would be you can ask the authority, the German pension insurance, to check the status of the worker. There are documents and also some comments on the homepage of the Deutsche Rentenversicherung. You can fill this out, send it to them, and then you will receive a response. And the next question then will be, is this really a good tool to mitigate the risk? We can discuss this later. I have some concerns.
Yeah, well, as we think we all accept, there's no perfect solution. I think it's a case of some processes better than none. Keep an accurate record of what you've done and how you came to that conclusion. So if you are in front of a court, then you can obviously present the process back. I think we definitely observe in the UK, but also globally now, there are many businesses that are engaging workers and not paying close attention to that status test. So any form of process around it, I think, is good. And the way the landscape's moving, with all governments trying to tighten up on this, and so it's really prudent to try and get an accurate process in place and mitigate those risks where you can. But let's move on away from worker classification and let's have a look at some of the other topics that we were looking about. So we've talked about classification into employed models or non-employed models. Probably useful to have a look at the different sort of types of engagements for workers, so how workers can be engaged, and also a bit of a discussion around the types of suppliers who can then provide those workers. So probably useful to mention and outline to the audience a definition around providers and solutions. So I use the terminology, which is quite common in the market, of employer of record or agent of record, which is often a reference to a business who can become the contractual employer of a contractor, and then that work can be provided to a business. Companies like Giant Global can help workers or help businesses tap into those talent pools and engage workers on that basis. From an EOR perspective, that is definitely an employed option. The work has an employment contract with the supplier, could be an open-ended one, or it could be on a fixed term basis, but each month generally there's a payroll run. The worker receives their net pay along with a pay slip, and all the taxes are deducted at source, and all the employment costs that are due are paid by that employer of record and paid to the local authorities. That leaves the worker therefore able to focus on doing the role, and obviously that their personal taxes are also paid on their account as well. From an AOR perspective, or agent of record service, that's where a worker is operating through some of those self-employed pieces that you mentioned before, Thomas. So either working through a limited company or a GmbH business in Germany, or potentially engaged and paid as a sole trader, so then receiving income and then having to declare their taxes to the authorities themselves. In those solutions, the workers receive a gross payment, either to themselves directly, or that gross payment is paid to the company that they're working through, and it's their responsibility to deduct tax. And of course, it's that key point as to why the worker classification piece is so important, because obviously the authorities are keen to make sure that people are paying the right tax where it's appropriate. I think that's pretty much the sort of broad range of engagement types. There's also obviously on top of that, and you referenced it earlier, the subcontract arrangements or consultancy engagements on a statement of work basis. Again, that's a company providing services, but defined based on milestones within contracts, and often contractors are used underneath those models to deliver those services. So important to understand the various engagement types. Thomas, it'd be good to get your views on the sort of considerations around worker engagement types in Germany.
Mm-hmm. So if you're familiar with the US and the UK, it's relatively easy for you to understand the German system. Most of the engaging types come from the US and the UK. So you're familiar with that. If we talk about EOR, employer of record, relatively new in Germany. I've been advising in the EOR industry for about 8 years, advising some of the largest EOR providers in the world, setting up their business model in Germany in a proper way. That's very common, very attractive at the moment in Germany. And I think it will stay because it has a lot of benefits for in particular the German market. The standard model of an employer of record in Germany is IUG, employee leasing, and that means that the EOR provider engages the worker and the client that brought the worker to the EOR provider will use the work of the worker. That's in Germany, this AUG, employee leasing. There are other models of EOR that are not the traditional EOR models, that go more to consultancy solutions models, but that's relatively specific. What we don't have is, and that's relatively specific in Germany, that's employee leasing, which is also used for EORs. The recruitment company, the staffing company engages workers and places them at the client. The client will use the worker, can direct them, control them, monitor them, integrate them into their client's organization, and the staffing company takes care of the formal relationship.
So Thomas, in that arrangement, because it's interesting, this employee leasing piece, who is the actual employer of record generally then? Is that the agency still in that scenario, or is that the client, or is that a third party? How does that work?
It's a split employer. So the formal employer is the employer of record, the agency, and the actual employer is then the client who uses the worker.
Okay, so it's what we might describe as a co-employment type model then, basically.
Yes, I heard this. The difference is the formal employer is the EOR provider, and the client is not the employer but has some employer rights. And the co-employer is if you have two employers.
Yeah.
So, and I would not call you can say that the client is a kind of employer, but the formal employment relationship is with the EOR provider.
Yeah. So the EOR is the employer of record. They take on the risk. The client obviously they're working under the supervision, direction and control of the client, but in essence, any of the tax and employment risk would sit with the EOR in that employer leasing arrangement, correct?
Yes, mainly. It could be as in every supply chain, with everyone in the supply chain, and we've seen this, but mainly it's the EOR provider. That's why you pay and instruct the EOR provider.
Okay, and it's interesting obviously we talked at the beginning about the risks associated with getting misclassification wrong. I wonder how that translates then. If just your comments on the German market, what's the most common way that workers are engaged that you see? Are they all on an employed basis, or are they all operating as independent contractors?
Yeah, that's a very good question. So we have quite a lot of employees, IEG workers, employees under an EOR model, and we have a high number of independent contractors, and this number is increasing because we see that there are a lot of highly skilled people who do not like to be in a dependent employment relationship. They would like to work as independent contractors, and even if I sometimes say, this is too risky, you should not engage this worker as an independent contractor, the answer can be, okay, we would like to engage him as a worker, a dependent employee, but the worker said, no way, I will be an independent contractor. And I say, yeah, it's nice that he thinks that he is an independent contractor, but in reality he is not. And then the question is, if the worker does not want, sometimes clients then engage this worker as an independent contractor, knowing the risks.
Yeah. Well, and that's business at the end of the day. There's also commercial considerations as well as risk, and we're all, I suppose, trying to make decisions on that spectrum, whatever our risk profile is and whatever the commercial position is. So I think that makes sense. Just a reminder to the audience, if you've got any other questions that you want us to address, I can see a few coming through. Feel free to put those into the chat. We'll make sure there's plenty of time at the back end of the session for Thomas and I to address those. Yeah, so I think let's move forward again then in terms of the topics and discuss the responsibilities and compliance requirements that are in place in Germany for these types of providers of workers. And what I mean by that is specifically recruitment businesses and payroll providers, or even recruitment platforms that supply workers. Thomas, can you just talk us through some of the compliance requirements for suppliers of temporary worker or contingent labour, please?
Mm-hmm. So for independent contractors, we discussed, yeah, you need to have some kind of independent contractor compliance system in place. And even if it's a checklist, yeah, proper contracts checklist, and then take care of the practical execution, that will definitely help. With respect to agency workers, AEG workers, the most relevant point is that you need to have an AEG license in place. That means the staffing company that places the AEG workers needs to have an AEG license. It's not rocket science, but it's some kind of work. Then you get the AEG license, and there are several requirements that you have to meet because it's a very regulated area. The two most relevant points are you can place an AEG worker at a client for, in general, up to 18 months. So we have assignment limits regarding AEG workers. And then the next topic is that usually you have to meet the principles of equal pay and equal treatment. That means if there's a similar employee engaged by the client in a similar role, you have to grant your AEG worker at least the same working conditions that the permanent employee at the client has.
And this is agency worker regulations, I think, the European legislation that you're referring to there, right? Yeah.
Exactly. Yeah, we have deviations. You can deviate from this principle in collective bargaining agreements. We have one. It's the most relevant one in Germany. It was formerly BAP and IGZ. They merged, and that is the standard collective bargaining agreement in the industry. So if you use one agreement, then it will be probably this one. If we're talking about EOR, it's important that you have a proper business model. EOR is, you will not find a lot of literature about EOR in Germany. You will not find case law. So it's developed from the US and from the UK into the German market. The standard model is, as I said, employee leasing under the AEG. That means you have to meet the requirements that we just discussed. If you use another business model, that's possible, but then you have to separate the different types of business model, and you have to take care that you execute it in the right way.
That's interesting. It's actually, I'll just pull out one of the questions asked from Sophie. Thanks for the question, Sophie. Just on this point, she was asking, are there any tenure limits for those workers that operate under EOR? You mentioned tenure limits for AUG workers, but do those tenure limits apply to those working under EOR?
Yes, very good question. Since the standard model is employee leasing under the AUG, we have the same tenure limits, assignment limits of, in general, 18 months. And therefore, if we advise EOR providers or clients who would like to use an EOR, we ask at the beginning, is this placement, is this assignment for a period of up to 18 months, or can it be longer? And if it's clear that it's not longer than 18 months, fine, you can use the standard model. If you know it will be longer than 18 months, or it could be longer than 18 months, then you should think about a separate model.
Brilliant. There you go, Sophie. I think that answers your question. But if you've got any follow-up questions, feel free to add them into the section. Okay.
Yeah.
Going back to that in terms of different types of contingent workers, I think we'd any comments around SOW there, Thomas, and how that should be managed or defined?
Yeah, a general comment from my side. What I see from the practical experience is the service description. That is so relevant in any contract, whether it's a service contract or a statement of work. It needs to be clear what are the agreed services. And sometimes I have a look at particular if it's a statement of work, services, software. Okay, that's it. Sometimes it's so short you can't understand what is meant, and you should invest some time together with the recruitment company or with the client, but the parties should invest some time to describe what is expected and what shall be the services. Because at the end, yeah, if you're not clear about the services, the product will be unclear, the price is unclear, liability is not clear, and if you then use independent contractors, you have a high risk of worker misclassification, because authorities and courts will argue, the description of the services is not clear. That means there is someone in the actual implementation of this project who tells the independent contractor what the independent contractor has to do. And then we are in monitoring, controlling, directing the contractor. And that's a fundamental criterion for dependent employment. So the proper service description is extremely relevant, yeah, in particular when it comes to statement of work.
Yeah. Makes sense. I think that's great advice. Properly defined milestone payments, be really clear, and not try and make it, certainly try and keep it as far as you can away from hours and day rate type arrangements where possible. So thanks for that, Thomas. I think given at Giant we operate a wide variety of payroll solutions in lots of different countries, we've got to continually be aware of legislations that are taking, legislations that are changing. So I think it's really important to work with a specialist like Osborne Clarke. Shameless plug for you there, Thomas, but for sure it's really important that you've got the right support to give you feedback on that. And if you need advice, then certainly seek it from the experts and look to work with suppliers that can engage with and operate a wide variety of solutions, because as we've seen, there's a whole variety of different arrangements out there, and that means that it's not a one size fits all. You need to adapt the offerings to suit the particular circumstance, whether that's with the client or indeed the assignment that's being put forward. So let's finally move on to our last set question. Thomas, we've obviously talked about lots of legislation today, and we would like to hear if there's any more on the horizon, if there's any other updates coming from Germany that people should have an eye on if they're looking to operate or currently have operations in Germany. Yeah,
there is one act coming that is very good for companies doing business in Germany, and that refers to a written form requirement. We have a strict written form requirement in different areas. For example, if you would like to terminate an employment relationship, this requires written form, so wet ink signature, not even a qualified electronic signature, wet ink, original signature. And
old school,
very old school, yes. And we had 2 years ago, we had a very nice new act, the Evidence Act, based on European law, but the European legislator said electronic signature is fine. Our government, which mentioned in the coalition agreement that digitization is extremely important for Germany, decided, oh, electronic form is nice, but written form is even better. So you have to inform the employee about the main working conditions in written form. That means original signature. We have the issue that there are a lot of fully digital companies that do not even have one piece of paper or a pen. And then we have to find solutions. How can they meet the requirements of this Evidence Act? Also, staffing and recruitment companies doing business in the employee leasing industry. You needed to, or up to now, you need to have a wet ink signed client agreement about employee leasing. So original signature. And this will be changed. It's not current law now, but it's in the last steps. So we expect that in the next weeks this will be the law, and that will definitely help companies. Then we have another topic that was discussed in the last two coalition agreements, and it refers to worker misclassification. The government would like to have all independent contractors covered by pension insurance. So the idea is that the independent contractors have to become members of the German pension insurance, so like an employee, or they have to take private pension insurance that on a similar level as the employees' pension insurance. This is in discussion, or has been in discussion for years. I do not know whether this will become law at any time. It would help reduce the risk of worker misclassification. It will not eliminate it, but it could reduce the financial risk of worker misclassification. But it's in discussion for so many years, and we do not see that it will become a law. But that could be an interesting point.
Yeah, good. Well, good certainly to put that on the radar, and definitely keep us up to date on those changes. Let's start to look at questions. So a reminder again, guys, if you've got any questions, we've definitely got a few to go through now. Please submit them now, so we've got another sort of 14 minutes or so to run through those. At this stage, I'd just like to say thank you, Thomas, for your insight today. super interesting, really useful to understand those variations, and hopefully that's helped the audience be mindful of the topics to bear in mind. Going into questions now for the last few minutes. So first question I have here is specifically on the AUG licensing piece. What are the requirements for a recruitment business looking to set up in Germany and get an AUG license? What's the process?
Okay, it's a lot of documents that you have to provide. I can't mention them all, but it's, when we prepare such a list, it's a list of about 2 or 3 pages. So you need to have founding documents of the company, the documents relating to the managing director or directors, criminal records, then several certificates. You need a bank certificate that you have sufficient money available. So for example, 2,000 euros per agency worker. That means if you have 10 agency workers, you need to have at least 20,000 euros on your bank account. You need to have a certificate from the health insurance companies that everything is fine. You need to prepare a draft employment contract for the agency worker. And you need to prepare a draft agreement between the staffing company and the client about employee leasing. And that's quite a lot. And sometimes it's difficult to get all the information at one point in time, because the employment agency does not like to receive one document and then the other and the other. They say, if you have collected all the documents that are required, send them to us and we will decide. And sometimes it takes some time to get all the documents. So from a legal point of view, it's not that difficult. every application that we made was successful, but sometimes it took some time. Yeah. It can be the fastest would be about 4 weeks. In general, I would say between 3 and 6 months. That means if you plan to do employee leasing in Germany, you should not start with the application process when the client asks for that. Some months before would be good.
Yeah, some prior planning and plenty of ink and pens to do your wet signature approach as well. Or can we get away with any online submission on those forms, Thomas?
That can be done electronically. Yes.
Fantastic. Okay, question from Zoe. If we had a requirement to have an engineer on site in Germany for a project doing ad hoc IT work, or secondly, a requirement for a full-time person in Germany, could we do this on an AOR basis, as I have only looked at EOR so far, and it's very expensive? And we were referring to that before on the commercials, weren't we? And then a sub-question, and is AUG only relevant to AOR models?
AUG license is linked to EOR, employer of record, because we are talking about employees. AOR, we are talking about independent contractors. You should not use an AUG license. And then depending on the project, I personally do not have an issue with a worker being engaged as an independent contractor, even if the worker works full-time for a client. Authorities and courts do not like that because they say, this is similar to an employee. And that's a relevant point that if you keep one thing from this webinar, then maybe this. German courts and authorities think, is this done in an employment relationship, or can this be done in an employment relationship? And if the answer is yes, they say this is worker misclassification. Example, the worker works remotely, not at the client site. In the past, it was a fantastic criterion that the worker was not integrated into the organization of the client. So that was a good criterion for independent contractor relationship. The authorities and courts now argue, particularly since the pandemic, a lot of employees work from home or remotely. So working remotely is an indication for an employment relationship. It's crazy and it's not correct, but that's how they argue. And therefore, I would be cautious. Yeah, if someone works full-time, they will definitely use this as an argument for a dependent employment relationship. So we have to have a look at the specific project, whether this can be done by an independent contractor.
Yeah, I think I agree with what you've said there for sure. I think it'll be the circumstances and looking at that engagement, Zoe, and how you can craft it. Can you craft it into a statement of work type arrangement, ideally? And if not, then how can you define the working practices there to try and ensure that it does look and feel like an independent contractor arrangement? So more than happy, I'm sure Thomas or I, to give you some support on and delving a bit deeper on that. Okay, next question from Michelle. Is the German government concerned about the number of remote UK freelancers providing services from the UK to German companies?
So I have not heard anything from the government, but what we see from the alien authorities, that's a shame. Yeah. Although there was Brexit, we always had very good relationships to the UK. What we've seen in the recent past was when recruitment companies wanted to set up in Germany and wanted to bring UK employees to Germany, we had seen some issues with getting the relevant residence and work permit. It was not funny. And we supported them and said, look, you have to grant them the permission. That's not okay what you're doing. So It could be an individual case. We've seen it several times, but in general, the government is absolutely happy that UK people are coming to the German market. And the reality is we are happy about every highly skilled worker coming to Germany because we do not have them. We need them.
Yeah. And I think, and as well to Michelle's question, she's also referring to remote workers. So I think it could also apply to workers who are actually sat in the UK delivering services from the UK to German businesses. Are there any concern there from the German government about the delivery of that?
No, the big question is about all the remote work done by independent contractors. It will not, the German pension fund will not benefit from it, because the work is done in the UK. So you would have to find a structure that the work is done in the UK, but the results will be effective in Germany. But we do not have any international social security law, and that is the point. Yeah, and if the German pension fund sees we can't get money for our system, they will not investigate. So at the end, it's okay. What we see is when UK staffing companies come to Germany and provide services for very large and very important German clients, then it could be that in case of worker misclassification, even if there are more criteria that the end client has worker misclassification, that they say, we do not want to contact the good German, very important company. We contact the UK recruitment company. That could happen, yes. And that's not only my personal experience, that's what I heard from judges at several social courts in Germany.
Okay, pick on the UK recruitment business rather than the large German corporate is the approach that would try and take there generally.
Yeah, but that applies to everyone. Yeah, so I would have a look. Maybe not the biggest German clients. It's nice, you would get a lot of work, but if you have some smaller clients, middle clients, also fine. It could be that with respect to worker misclassification, it's not that critical, but that's very specific.
No, it makes sense. I think that's good advice. A question from James. If the staffing company doesn't have a trading entity in Germany and therefore doesn't have an AUG license, what options would they have if a client wanted their support to source for their contingent workforce? So I think that's a good question, James. I think that goes back to what we've spoken about in terms of the providers that are available in the market, such as employer of records like Giant Global, who can effectively engage that worker, ensure if they are needing to be employed that they have the employment rights and the right taxes are deducted, and supply that worker through to that business. You would agree with that? You would agree with that, Thomas?
Yes, definitely. That's
and obviously
nice.
Yeah, and I think also around AUGs, what probably worth just as a final point as we wrap up, worth mentioning how the chain law works on this as well, because obviously you've got to be conscious of how many parties are operating in that supply chain as well. Could you just briefly outline that for us in a few seconds?
There must be a direct relationship between the staffing company and the client who uses the agency worker. So it's not possible to have a supply chain with respect to employee leasing. There must be a direct relationship. And that's why the employee then should be engaged by the EUR provider like Giant. And for the other company, it could be a margin-only contract, but they can't be in the supply chain. And we also see this with respect to MSP structures. If there is employee leasing involved in an MSP structure, you need to find a different structure than the traditional US or UK model. But that's possible.
Yeah, no, great. I'd agree with that, James. We can follow up afterwards as well. Certainly, it is definitely you're capable of doing that. It's just about making sure you've got the right supply chain in place, and there's not too many parties in that supply chain to break the legislation on that. The hour's flown by, Thomas. We really appreciate your insight there, and thank you to everyone who's took the time to join us this afternoon and ask those questions. Really pleasing to cover those topics. I'll continue to run these spotlights on other topics, so that please do keep your eye out for other webinars and sessions coming up in the near future. And it just remains for me and Thomas to both say goodbye for the day and enjoy the rest of your afternoon. Thanks for attending.
Thank you. Have a good day.